Alright, I'm pretty deep into this application for a writ of review. I've been working on it for a few days. I have till, well, I would say my trial, which is November 12th. I want to say November 18th, which would be the full month. And maybe I could try to make the court aware of that I do have the 30 days to complete the motion or the appeal, the writ. I mean, that's within the rules at least. I could just state the rules and ask for the extension for that rather than have the trial date on the 12th. But yeah, I'm pretty deep into it. Almost done, so I guess maybe I could just try to quickly submit it anyway. I need table of contents and table of authorities. But this is what I have written. Okay, well, this is what ChatGPT has written, at least. Comes now, Travis Heinze, petitioner pro se, respectfully requests this honorable court to review the rulings made by Judge Brian Barber in Natchitoches City Court on October 18th, 2024. These rules resulted in the denial of several key motions and the issuance of a bench warrant for the defendant's arrest. This application is made pursuant to Louisiana law with arguments based on both procedural and substantive errors by the lower court, which violated Mr. Heinze's constitutional rights to due process, his right to be present, his Fourth Amendment rights, and his right to a fair trial. Additionally, Mr. Heinze has consistently remained under the jurisdiction of Louisiana appellate courts, including the Third Circuit Court of Appeal and the Louisiana Supreme Court throughout prior proceedings without issues of noncompliance or procedural enforcement actions required by these higher courts. Statement of jurisdiction. This honorable court has jurisdiction over this matter pursuant to Article 5, Section 10 of the Louisiana Constitution, applicable Louisiana statutes and court rules. The rulings in question stem from the proceedings in Natchitoches City Court on October 18, 2024, which resulted in the denial of defendant's motions and procedural orders impacting the defendant. This court, as part of the Louisiana Third Circuit Court of Appeal, retains jurisdiction to review the procedural and substantive decisions made by the lower court. Furthermore, the defendant has remained under the jurisdiction of the Louisiana appellate courts, including the Third Circuit. Okay, all right. Wait, I did repeat myself there. Yeah, it's consistently remained. I don't know about the additionally, because I'm saying that twice actually. Furthermore and additionally, consistently remained, has remained, including, and they saw, yeah. I think, I don't really need additionally then. Okay, let me, I need to change this up a second. Let's see, find and replace doc. Okay, viewing mode, getting out of viewing mode. And honestly, I don't really want this. Maybe I could just ask that the introduction. In fact, there's really no introduction in my former lawyer's writ. So it may not be so necessary to even have an introduction. So it doesn't really need to be long. Okay. But yeah, that repeats a little too much. It does. You don't need to say much in the statement of jurisdiction. And yeah, I'll keep the paragraph in that, the second paragraph in this statement of jurisdiction. Issue statements: denial of motion for continuance and remote participation. Did the trial court err in denying Mr. Heinze's motion of continuance of the trial date and request for a Zoom hearing, thereby violating the defendant's right to participate in court proceedings? Failure to appoint counsel. Did the trial court err in failing to address the defendant's request for court-appointed as counsel after his previous legal representation was terminated in violation of defendant's Sixth Amendment right to counsel? Denial of motion to recuse prosecutor. Did the trial court err in denying the defendant's motion to recuse the prosecutor without a substantive review of potential conflicts or bias, thereby denying the defendant a fair trial? You know, this isn't quite finished. I think I want to explain the failure to appoint counsel. Yes, well, that's the thing. I'm looking at this stuff and I'm like, okay, maybe something could be changed here, because my lawyer pretty much threw me under the bus, my former lawyer, by saying that, you know, it's something I wanted primarily. He said that he wanted it. If he would have just focused on his withdrawal as just his decision, because, I don't know, we weren't getting along with each other, that would have been fine. But he had to throw me under the bus by saying that I wanted it. It was my decision mostly anyway. So that was something brought before the court, and that does need to be addressed. And I would want to address it by saying that I've run out of money. I mean, I can't be tapping people for money all the time over this issue. The same issue, the same court case, 170-969. And I think I want to address that by saying that the money is run dry. But I mean, yeah, this argument is focusing on the failure, the trial court not addressing the attorney issue, just kind of laughing at the fact that I lost an attorney, that I've done it to myself, and that we're going to proceed with me without a lawyer. And I think that, and I think the appeals court will see it that way as well. So I think I want to address the money issue. Get that? I mean, but so did the trial court err in failing to address the court-appointed counsel after his previous legal representation was terminated in violation? Okay, I mean, that's the basic core of it, though. That's the thing. You're talking about addressing the issue, and then when we address it, that's when we talk about the cost and all of that involved. So really, I'm just focusing on the initial aspect of the attorney issue. And that's just simply addressing it at the start, which it was never done. So really, to get into money issues on top of that, that's step 2, and you can't skip step 1. So maybe it's okay. Maybe it's okay. Just I got to think about it. Did the trial court violate the defendant's right by refusing to consider the constitutional arguments raised in Mr. Heinze's motion to quash the charge against me, particularly concerning Fourth Amendment protections against unreasonable searches and seizures, improper issuance of bench warrants? Did the trial court err in issuing a bench warrant for the defendant's failure to appear despite Mr. Heinze's attempts to participate remotely, and where no such warrant was issued during the period he was under the jurisdiction of the Third Circuit Court of Appeal in the Louisiana Supreme Court? And wow, I think maybe I might want to address that it's a faulty warrant as well. Well, I addressed it by also putting out a quash bench warrant directly to the trial court, because I know that's what the appeals court will ask. Did I put out a motion to the trial court? And so I want to prove that too. You know, assuming this all goes through, I'm writing it, but you know, it's hard to say if it'll go through. Improper discovery order and violation of Fourth Amendment rights. Did the trial court err in ordering the defendant to provide evidence to the prosecutor violating the defendant's Fourth Amendment right against unreasonable searches and seizures? So yeah, once again, Cloyd asked to see everything that I have. That's his standard question. And now I think since there was a ruling on that, I can appeal it, or I can writ it. Due process violations and denial of appeal rights. Has the trial court's improper handling of records, misrepresentation of motion dates, denial of the defendant's rights to appeal while incarcerated, and failure to accommodate the defendant's participation via Zoom violated his constitutional right to due process? Denial of access. Wait a second, why are they looking different? Oh, I see. Denial of access to unredacted police policies as a pro se defendant. Did the Trial court violate the defendant's right to a fair trial and due process by denying the access to unredacted police policies necessary for defense preparation. All right, so that's number 8. Oh, I do have it. Okay, I think I want to keep that in. And then the assignment of errors is pretty much turning the questions into statements that yes, 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 as all questions are yes. Statement of the case. On October 18th, and I'm just entirely focusing on the court minutes for October 18, 2024. I'm really not bringing anything extra into this argument. It's just all focused, my writ is all focused on the decisions Judge Barber made for all of the motions, all of them. So, I mean, and the thing is, because I wasn't there, the appeals courts will say that I wasn't there to object. So, you know, they assume that I was in agreement of that. And what I need to mention is that really the court hearing was the prosecutor motions for the court hearing to be a status conference, which is considered a more formal or a more less formal way of meeting, whereas a hearing is more formal. So I want to argue that, and I haven't actually. I want to bring that in now that I'm thinking out loud about it. The prosecutor made a motion that he wanted a status conference, and Judge Barber agreed to that. So actually, before I go further now, I do have something else to add, and because that's not mentioned in here. Yeah, all of these points are mentioned, but one of the first things I want to mention then is the fact that, yeah, I really need to, let me just put a note on the top here. I'll just sort of stop it at this point, stop with the reading, because yeah, it's Cloyd Benjamin, Cloyd requested the hearing date to be converted to a status conference. Which is considered more informal in nature, and generally there's no real rulings involved. No rulings are made. It's just discussion. So that's, you know, something that the prosecutor did when I couldn't make it. That could be seen as an advantage. I don't know what's going through these people's minds. They're crazy down there. But I think, yeah, that's not something I mentioned before that I'm now mentioning. As I think about this out loud, I guess new thoughts, new ways of thinking come in here. So I guess that's where I'm kind of stuck at. This whole thing needs to now be needs to add that. I got a few pages. I don't know how many. I really can't seem to page count on the tablets. I can do it on the laptop. So I want to get on the laptop as soon as possible. But yeah, that's where I'm at with this. I got several arguments. It's mostly written by ChatGPT, just helping out with ideas and stuff. I just kind of submit what I know and then ask it to form the stuff. I went off of also my old lawyer's writ, just for the formatting. So yeah, that's where I'm at with it right now.